Good evening. I'm Jessica Butler, and I currently practice as a licensed professional counselor. I've been providing individual and family counseling for a little over 5 years. And one of the most difficult aspects of being a therapist working with children and adolescents and their families is navigating the complexities of divorce and custody issues. And so today it is my hope that I can assist future marriage and family therapists by enhancing their understanding of divorce related legal processes and ethical considerations regarding the role within marriage and family therapy. And so therefore, in this video, we will cover the general divorce process, child custody issues, considerations for evaluating child custody arrangements, or mental health of a caregiver, American Association of Marriage and Family Therapy ethical considerations, and then lastly, some tips for releasing information when subpoenaed. So let's dive in and begin with some statistics. So, research has shown that divorce rates are progressively decreasing. Emery, Rowan, and Dinescu suggest that these statistics are quite misleading due to the increased age of individuals entering into marriage for the first time and the fact that there is an increase in number of individuals who are choosing alternative means to marriage. However, statistically, nearly 50% of first marriages still end in divorce. As we know, divorce contributes to risk factors for all members involved. According to Paul Amato, the divorce process involves stressors to include loss of emotional support for both parents and children, loss of contact with one parent, economic decline, psychological and behavioral problems, and continuous conflict between parents. And so, even in the best circumstances, the process of divorce forces all members into new roles and just completely complicates the family dynamics. Therefore, it is imperative that marriage and family therapists be aware of the legal processes for divorce to better assist clients as they matriculate through each phase of this process. Now, in order to do so, one must first consider the laws regarding divorce in the state in which you reside or which you're going to practice in. I currently practice in the state of Virginia, and the process for divorce in the state of Virginia is very similar to other states. For the state of Virginia, however, an individual seeking an uncontested or no-fault divorce must first be a resident of the state for a minimum of 6 months. They also must be living separate and apart from their spouse for a minimum of 6 months. If there are children involved who happen to be minors, then the length of separation, it needs to extend to the 1 year, again with an emphasis on living at two distinct residencies. In this particular case, the court may or may not request that they prove that they have been living in two different places. And so, after the period of separation is completed, the individual can file for divorce. Typically, it is during the waiting period that the couple, in the best case scenario, will actually create a separation agreement, discuss separation of property, child custody, visitation, and support. However, one can file immediately based on grounds for divorce as explained in Virginia law. And so some common at-fault acts include adultery, abandonment, and the other spouse actually receiving a felony after the date of marriage. So once filing a divorce, the process moves to dissolving the marriage, property assets, determining child custody, alimony, finalizing other terms for divorce, whether the divorce is considered uncontested or a no-fault divorce, or an at-fault divorce. This process heavily impacts the mental and emotional state of both parents and all children involved. It is actually issues of child custody that often cause individuals to present themselves and or their children for therapy. So when discussing child custody, an explanation of some terms can be helpful. So first we have what we call physical custody, which implies custody as it relates to where the child lives and rules of visitation. And then there's legal custody, which is where the parents make legal decisions about the child jointly or separately in terms of psychological and medical care, education, and religion. In the state of Virginia, there are three different types of child custody available. There is joint legal custody, where both parents, regardless where the child actually lives or spends most of their time, they actually retain responsibility for the care and authority of the child. Then you have joint physical custody, which refers to an arrangement in which the parents share physical custody and care of the child which usually involves alternating weeks or months or seasons and holidays. And then lastly, there's sole custody, where just one parent has physical custody and the authority to make day-to-day decisions pertaining to the child. The non-custodial parent in this arrangement oftentimes will seek visitation, and of course it will be granted at the discretion of the court. Now, in certain situations, marriage and family therapists will have to evaluate child custody arrangements or the mental health of a caregiver in addition to providing therapy. As an evaluator in this process, cultural competence is essential. Zimmerman and colleagues encourage that marriage and family therapists have cultural knowledge of the family's values, attitudes, and beliefs. In terms of reporting fairly to the court or assigned personnel regarding mental health of a caregiver, Zimmerman and colleagues also contend that you want to assess parenting abilities, behaviors, values, and belief systems, and communication between both parents. Both parent-child observations and assessment instruments are used to determine the child's needs and parent's capacity. The perception of relationship assessment, the MMPI-2, parent awareness skills survey, and other projective measures are frequently used as child custody assessments. In addition, direct parent-child observations or home studies and expert opinions are used to determine the best interest for the child. Now, the role for the marriage and family therapist is to offer insight on factors that determine the best interests of the child, assess family dynamics of both guardians, and the emotional functioning of the child or children involved. Ultimately, in the state of Virginia, youth at the age of 14, they are actually able to testify of their preference for custody. The court still considers these findings or the findings from the studies and instruments and expert opinions regarding custody. However, it is the child's wishes that heavily weigh on the ultimate outcome when they are of age. So under all circumstances, marriage and family therapists should be knowledgeable of the American Association of Marriage and Family Therapy Code of Ethics. The AAMFT Code of Ethics are unique in terms of confidentiality, as they consider that there may be more than one client in the therapeutic relationship. So according to the AAMFT Code of Ethics, it is important that each practitioner have a thorough informed consent, as well as initially and then frequently advising limits of confidentiality. Marriage and family therapists should also thoroughly review written authorizations and remain knowledgeable of ethical practices. It is essential that marriage and family therapists avoid dual roles, even in instances where your expertise is needed for a custody evaluation. You must still ensure that the custody evaluation and therapy remain completely separate. As previously mentioned, understanding the legalities of your state is very important. For example, in Virginia and even in other states, marriage and family therapists must understand that both parents have the right to be informed of treatment when providing therapy, and the child is the identified client. However, this is only relevant when the court issues joint custody for both parents. Oftentimes, while working with children and parents through a divorce process, multiple parties may request client records and or other client information. The American Psychological Association suggests that you first determine if the information requested carries the force of law. There will be instances in which the parents' attorneys may request client information during the divorce process, and in this instance, the therapist is not legally required to release client information. However, a valid court-ordered subpoena requires that information must be released as assigned by the court, or may require that the therapist actually appear in court to testify. Now, once one determines the presence of a court-ordered subpoena, it is best that the therapist utilize the attorney provided by either their state association, or if one is provided legal counsel through their mental health employer. Also, if you are a member of the American Association of Marriage and Family Therapy, there's a legal consultation process that is afforded to you as well. It is imperative that one know if they are required to appear in court, and if so, when you should probably appear in court. It is also important to know what documents or information is required at the time of court. As you're preparing to go to court, it is a good idea to only bring the most pertinent information that is needed, maybe just a few things that will jog your memory. For example, in Virginia, any documents that are brought into the courtroom are automatically accessible by the court. So should the therapist have any information that is not helpful, or that they really don't want to share unless it's directly asked, then in that case you want to make sure that you only have the bare essentials for what you need when you're going to court. So, should the therapist deem that client records or other client information not be released due to potential harm to the client, then the therapist can go through the process to quash the request. Significant justification is needed to engage in this process, and it should be done prior to appearing into court. There are numerous idiosyncrasies involved in divorce and related legal issues, and this topic shouldn't be taken lightly. Hopefully, I've assisted with some education regarding the matter, and I definitely encourage you all to seek out pertinent information and processes regarding this topic as it relates to your individual state. So, I hope this has been helpful, and I wish you guys the best of luck. Thank you.